What is your name?
Mr. Salary,
Well, okay, I thought we were doing Ison first, but all right. So we'll do Mr. Sowers. You're Dustin L. Sowers? All right. Okay, this is case number, have you got us on record?
Yes, sir.
Okay, case number 21 CR 0086, State of Ohio versus Dustin L. Sowers, S-A-W-A-R-D-S. Mr. Sowers is appearing from the jail by Zoom. His attorney is Jake Wagner, appearing from his office, and the state is represented by Assistant Prosecutor King, appearing from his office. Mr. Wagner, you and your client both agreed to have this hearing conducted remotely by Zoom rather than requiring an in-person court appearance.
you do, sir.
And you're in agreement with that, Mr. Sowers? All right. The defendant is charged with aggravated trafficking of methamphetamine and aggravated possession of methamphetamine, both third-degree felonies, and the matter is set for trial on March 7th. The court has received the plea of guilty form. Mr. Sowers indicating that you're going to withdraw your not-guilty plea, plead guilty to count 1. I'll hold this form up to the camera so you can see it. It has your name, case number there, and says plea of guilty. You see that there? All right. Then on page 3, there are signature lines, and about halfway down the page, there's a sentence that says, "I entered this plea voluntarily." Right below that, there's a signature which appears to be Dustin Sowers. Is that your signature?
Yes, sir.
All right. When did you sign this document, Mr. Sowers?
About an hour ago.
All right. Mr. Wagner go over this with you before you signed it there at the jail?
Yes, sir.
And did he explain everything to you and answer all of your questions?
Yes, sir.
And did you understand that this is an agreement to plead guilty, which means there won't be a trial? The next step in your case would be a sentencing hearing?
Yes, sir.
And is this something that you and he had talked about before you came to see you today?
Yes, sir.
You feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
All right, now the agreement states that you're going to withdraw your not guilty plea, plead guilty to count 1, aggravated trafficking of methamphetamine, under section 2925.03A1 of the Ohio Revised Code, a third-degree felony. Further states that you understand that the maximum penalty that could be imposed to that would be a prison term of up to 36 months. The minimum would be 9, and there's certain levels in between those two ranges. There's a fine available of up to $10,000. There's a mandatory fine of up to $5,000, and a license suspension of 6 months to 5 years. And this is a charge or an offense for which the legislature has said that there should be a presumption that a prison term is required. It's not mandatory, but it's presumed that that's the correct sentence. You understand all of that?
Yes, sir.
Now, other than these charges, are you facing any other felony charges in any other court?
Yes, sir.
All right, and are you currently on probation, community control, parole, post-release control from any jurisdiction?
Yes, sir.
Now, under the law, if you are convicted of this offense and sentenced to prison, once you complete your prison term, the law provides that the adult parole authority may, if their option, decide that you should be put under post-release control supervision for a period of up to 2 years. What that means is that they would set that, not the court. The court doesn't have anything to do with it. And if they decide that that should be done, you'll be supervised under the terms they set by a parole officer. If during that period of time they feel, the parole authority, that you have failed to comply, then they can return you to prison. They can serve an additional period of up to 9 months for any one violation. But there is a cap or limit of cap of whatever prison term is imposed for all violations. But if you commit a new felony while you're under post-release control supervision, then in addition to whatever sentence the judge in the new case proposed upon you, that judge can also sentence you in this case, or I shouldn't say in this case, but for committing that offense while under post-release control and supervision in this case, to an additional period of a year or whatever time is left on the post-release control, whichever is more or greater. And if that occurs, that would have to be served consecutively to the sentence for the new offense. You understand that?
Yes, sir.
Now, I mentioned earlier it's not mandatory that you be sentenced to prison for this offense. I do have the authority to impose community control. and that means that you don't go to prison, instead you're put under supervision of a probation officer for a period of up to 5 years under the term set by the court. And if during the period of time that you're under supervision, the probation department feels you're not complying, then they would file a written allegation of that with the court. There would be a hearing, you'd be entitled to be represented by an attorney, and if the outcome of that hearing was that you failed to comply, then at that time, the court would revoke your plea control and then sentence you to prison for 36 months, fine you $10,000. You understand that?
Yes, sir.
Right now, the charge alleges that on or about September 3, 2020 in this county, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance amount equal to or exceeding bulk amount less than 5 times bulk amount, in violation of Section 2925.03A1. So that's the aggravated trafficking methamphetamine charge, third-degree felony, as we just discussed. Now, do you understand the charge, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
Do you understand the possible penalties for that offense?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise in the trial, and possible outcomes of the trial with your attorney?
Yes, sir.
Are you satisfied with this advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any kinds of prescriptions there at the jail?
Yes, sir.
Has anyone threatened you to make you plead guilty here today?
Yes, sir.
Now, at the bottom of page 2, there's 4 lines and printed in bold and underlined. So I'll read those at this time. Defendant shall enter plead guilty to count 1. State will dismiss count 2. State and defense jointly recommend 24 months. State agrees not to pursue an indictment for failure to appear arising from this case. Defendant agrees to repay bond money to the Huntington County Task Force in the amount of $150. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
Yes, sir.
Now, under the law, the matter of sentencing is up to the judge, not the party. So even though there is an agreement that the sentence should be 24 months, I'm not obligated to follow that. If you plead guilty, I could impose any sentence that I think is appropriate up to, including 36 months in prison. Do you understand that?
Yes, sir.
Now, you have, do you hold any license or certificates from any state commission or governing body that regulates any type of a profession or occupation?
When I had completed the STAR program back in 2019, and I got a commercial and residential maintenance certificates.
All right, I think that's a trade, I believe. I don't think that's a state board. I think that's a state organization. But I don't think it's a state license. I don't believe.
Okay.
Okay.
Yes, sir.
Because if it is, the clerk will have to send a notice to them of your conviction if you are convicted. So.
Okay.
All right. Now, you have certain rights you must understand before I can accept your plea. First, you have the right to have an attorney. Mr. Wagner was appointed to represent you. That appointment wasn't simply to try to work the case out, but provide any defense that might be available to you under the law that you would like him to provide. So if you decide you don't want to plead guilty, that you want to defend against the charge, he will continue to represent you, including defending you in a trial if that's what you want. You understand that?
Yes, sir.
Under the Constitution, you have a right to a jury trial in this matter, Mr. Torres, in which 12 people would be selected from a group of citizens who live in this county that would be summoned for jury duty under your trial date. After those 12 were selected, they would be the jury, they would hear the evidence, and then be instructed on the law, and that jury would have to decide by unanimous verdict, meaning they all 12 would have to agree on the verdict as to whether or not the state proved your guilt. Now, if you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up in writing your right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning that instead of the jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proving beyond any reasonable doubt. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify for you, your attorney, and anyone else is present. And then after the prosecutor is done asking them questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Under the Constitution, Mr. Sarge, you have the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain crime committed voluntarily, at your request, the court issues a court order that's a subpoena, and of course those witnesses will come to court and be able to testify if you wanted them to, even though they don't want to be here. Which is the same way the state's witnesses are forced to come to court to testify against you. You understand that?
Yes, sir.
Under the Constitution, Mr. Shores, you are, have a privilege against self-incrimination. What that means is that you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to comment about it except in one situation. That is, if there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to prove you're not guilty. The burden is upon the state to prove that you are guilty. And in fact, you don't even have to present any evidence at all at the trial. You may, but you're not required to. Whether you present evidence or not, burden of proof will remain upon the state to prove you're guilty, prove beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right? Now, originally you pled not guilty. That plea denied the allegations in the indictment, denied you committed any crime, and that plea exercised or revoked all of the rights that I just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they are a crime, that you committed that crime, and that plea gives up all of the rights that I just described for you, except the right to have an attorney. You always have the right to have an attorney, no matter what your plea is. With that exception, your plea of guilty will waive and give up the right to have a jury or court trial, waive and give up the right to prompt witness against you, and cross-examine through your attorney, waive and give up the right to use the power of the court, compel or force witnesses to come to court to testify for you, the same as the state. It would waive and give up your privilege against self-incrimination because you're the one saying you're guilty, and that's what you find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I were to sentence you to the maximum sentence or under certain circumstances to file an appeal, that appeal would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, sir.
And are you a U.S. Citizen?
Yes, sir.
Right, now you have any questions about the charge or the possible penalties?
No, sir.
You understand it?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Do you have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
Yes, sir.
You understand?
Yes, sir.
Right now, is there anything you'd like to speak to your attorney about before we go any further? Because if there is, I can put you again into a breakout room where the two of you will be able to talk without anyone seeing or hearing.
No, sir.
Do you have any questions on anything that I've explained to you here today?
No, sir.
Then is it your decision, Mr. Soares, to withdraw your not guilty plea, plead guilty to the first count of the indictment pursuant to the terms of the agreement we just went over?
Yes, sir.
And as to the charge in count 1, which alleges that on or about September 3, 2020 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance in an amount equal to or exceeding bulk amount less than 5 times bulk amount, in violation of section 2925.038A1 of the Ohio Vice Code. The charge of aggravated trafficking methamphetamine, a third-degree felony carrying a possible prison term of between 9 and 36 months in the increments provided by law. The fine of $10,000 and a mandatory fine of $5,000 and a possible license suspension of 6 months and 5 years. How do you plead?
Guilty.
All right. The court finds on this date open court, defendants advised of all his constitutional rights made no intelligent voluntary waiver of the same pursuant to Rule 11, pleas in second order filed. Defendant is found guilty of count 1 as set forth therein. A third-degree felony. Count 2 is dismissed. All right. Since there is a recommended agreed sentence, the court will not order a pre-sentence investigation, will instead proceed to sentencing to court. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor.
All right, Mr. Wagner.
My client, and I'm treading lightly, sir, my client has requested, I'm of course, typical stance on furloughs and things of that nature, Your Honor. My client has requested, and I said I would do it ethically since he requested, but we'll tread lightly. He has asked me to set sentencing out or a report date just till tomorrow, Your Honor. I told him highly probably not going to happen, but I told him I would at least ask, but beyond that, Your Honor, we would ask the court to follow the recommendation.
All right. Anything you would like to say, Mr. Storrs? You're not required to say anything, but I'll hear whatever you have to say.
No, sir.
All right. Well, I did know that you had a previous felony of conviction of escape. Have you been to prison previously?
I took care of all that, and I went through STAR.
I asked you, have you ever been to prison? Okay. All right. So this will be your first time. All right. Well, it's the order and judgment of the court that you be and are hereby sentenced to the Correction Reception Center at Orion, Ohio, for a period of 24 months, and you'll be given credit of 29 days. They had you in jail from June 23rd until June 24th of last year, 2 days, and then from the 2nd of February until the day, 27 days. So 29 days of credit, plus and then of course you get credit until you're delivered to the institution, whatever that would be. Now, upon completion of this term, it is possible that the adult parole authority will exercise the option to place you under post-release control supervision for a period of up to 2 years. They don't have to, but they can. But if they do, you'll be supervised on the terms and conditions as set by a parole officer. And if during that period of time they determine that you have failed to comply, then they can return you to prison, make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term, which would be 12 months for all violations, so that's the cap. But if you commit a new felony when you're under post-release control supervision, then in addition, whatever sentence the judge in the new case can impose upon you, that judge would also be authorized to sentence you for committing that offense while under post-release control supervision, in this case, to an additional period of 1 year, whatever time is left on that 2 years of, up to 2 years of post-release control, whichever is greater. And if that happens, that has to be served consecutively to sentence in a new case. Now, you're also ordered to make restitution payable through the victim witness escrow account to the Highland County Task Force in an amount of $150, and pay any service fee that may be required. And that's a substantive order which will not be discharged even though you may serve all of your sentence. It does not go away until it's paid. You're also ordered to pay the court costs, which judge can grant an execution order. And if you fail to do that or make payment arrangements, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, and other assets that you may have. If that doesn't collect it, then once you complete your prison term, the court could order you to do community service, give you credit for each hour you work in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until it's paid in full. Yeah, I believe that's it. And as your attorney told you, I would have to be incredibly stupid to give you a day release on a furlough. When you took off in October, it took 4 months to catch you. So, I don't know what your screen looks like, but if you think you see stupid tattooed across my forehead, it's not. It's a mirage. So, it's denied. All right. Anything further, counsel? All right. You're named in custody. All right, Ms. Ison, please.
Your Honor, on this one, can we try to clear up the restitution before we?
Yeah, in other words, you want to check your boss's map? I would think that's a good idea.
So here's what I was able to figure out while we were. So the amount that was originally in the plea form, the $3,815, is correct. The reason that the totals don't add up to that is because there's another amount of restitution with a co-defendant that was not included. So the part that's missing is the $240 joint and several with Brian Conley.
All right.
And once that's in there, everything adds up to $3,815.
Brian Conley?
Correct.
Okay. All right, are you Jennifer Eisen?
Yes, sir.
Pardon me?
Yes, sir.
Okay. All right, this is case number 22-019, State of Ohio versus Jennifer R. Eisen. So Eisen appearing by Zoom from the Justice Center. Her attorney is Jacob Wagner, appearing by Zoom, and also representing the state is Assistant Prosecutor Kane, appearing from his office by Zoom. This matter is set for a plea hearing. Ms. Eisen has been indicted along with 6 co-defendants on a number of charges. The total number of indictments is 33. I don't know how many that are heard. She's not holding. Matter is set for a plea hearing today, and I've been presented with a plea of guilty for Ms. Eisen. Now, before I go over that, since we are doing this by Zoom rather than being in person, if you at any time need to talk to your attorney, you just tell me and I can put you and him into a breakout room where the two of you can talk. No one else will be able to see you or hear you until you're finished, and then you can come back and join the rest of us. Okay? All right, and Mr. Wagner, you and your client are both agreeing to waive your presence, physical presence in the courtroom, and agree for this hearing to be conducted remotely by Zoom.
We are, sir. Is that correct, Jennifer?
Yes.
All right, thank you. All right, well, for the record, it looks like Ms. Eisen's charged in counts 1 through 16, actually 1 through 1D5, and then count 33. So the 25 counts, and then count 33 is a forfeiture specification, which isn't a criminal penalty, but is a forfeiture of any property that the defendant has an ownership interest in, and that she's convicted. So I've been presented with this plea of guilty form, Ms. Eisen, that says you're going to plead guilty to counts 10, 17, 19, 21. Those are all criminal offenses, and then 33 is a forfeiture. Now, I'm going to hold this up to you, to the camera, and right there is your name, case number, plead guilty, and the counts. You see that there?
Yes.
And on page 3, there are signature lines, and right at the bottom, the last sentence says, I enter this plea voluntarily, and then immediately below that is what appears to be the signature of Jennifer Eisen, and I'll hold that up on the camera and ask you if that is your signature.
Yes.
When did you sign this document, Ms. Eisen?
A few hours ago.
There at the jail with your attorney?
Yes, sir.
And did he go over this agreement with you, read it to you, and explain everything to you?
Yes.
And did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes.
And have you and him been talking about that before you came here today?
Yes.
Now, you were just indicted, looks like on the 1st, and we don't actually have a pretrial set for this until Wednesday, but you've had plenty of opportunity to discuss this with your attorney and make this decision.
Yes, sir.
Do you feel that you've been rushed or pressured in any way into doing this?
No.
Are you entering into the agreement to plead guilty voluntarily?
Yes.
Right now, the agreement states, as I said on page 1, you're going to withdraw your non-guilty plea, plead guilty to counts 10, 17, 19, and 21. All of them are entitled aggravated trafficking methamphetamine under 2925.03A1 of the revised code. And all of them are second-degree felonies. Now, counts 17, 19, and 21 also include that it occurred in the vicinity of the school zone. But it's still the same section number and the same level of offense. And then count 33 is a forfeiture specification, which would seek to forfeit the property that's described in count 33, which appears to be a 2007 Dodge Caliper, $218 in U.S. currency, and 5 cell phones. So the penalty for that would be the loss of the property. Now, the penalty for the aggravated trafficking and methamphetamine charges under 2925.0381 are all a second-degree felony, and each of them carries a possible sentence to be imposed by the judge of between 2 is the minimum of 8, and the judge can pick any number in between those ranges. And those all can be ordered to be served consecutively. So if the maximum sentence was imposed of 8 years on all 4 counts, and they were all run consecutively, that would be a total of 32 years. Now, under Ohio law, for persons that are convicted of first or second degree felonies, and these are all second degree felonies, the sentence that the judge imposes is what the minimum is. And then the the Department of Corrections, Rehabilitation Corrections, then, which operates in the prisons, has the right to make you serve up to 50% of whatever sentence was imposed for one of these offenses. And so the example I believe is being used is count 1. And so what that means is that the potential sentence for that could be 8 years as a maximum. And then if the adult parole board or the Department of Corrections continue to hold you for an additional 50%, that means that could be up to 12 years on that particular charge. And then the sentence on the others would be 8, because under the law, that can only be done on one second-degree felony in a particular case. Now, each of these carry a possible mandatory fine of $7,500 and a mandatory possible license suspension of 6 months to 5 years. Now, I should say that whatever sentence that is imposed by the court is mandatory. So, for example, the minimum is 2 years, and if that was the sentence, that's what would have to be served. If it was sentence was 5 years on each count or a count, that's what it would be. So, and there can be no early release or reduction of that sentence. You understand that? Okay. Now, so as it stands, then the possible maximum penalty could be 36 years. The minimum would be 2 years if the court ordered all 4 of them to be sentenced concurrently. You understand that?
Yes.
Okay. Now, under Ohio law, once you complete the sentence imposed by the court, it is mandatory that you be put under post-release control supervision by the adult parole authority for a period of at least 18 months up to a maximum of 3 years once you're released from prison. So that means you'll be supervised by a parole officer on the term set by the adult parole authority, because the judge is not involved in that, has no say in it. And if they decide that you have failed to comply with the conditions, they can return you to prison even though you served the entire prison term set by the court for an additional period of up to 9 months for any one violation, up to half of whatever prison term the court imposed for all violations. However, there is a cap, set half of whatever prison term was imposed by the court. But if you commit a new felony while you're on post-release control supervision, then in addition to whatever sentence the judge and then indicates proposed finding, that judge could also sentence you in this case to an additional period, 1 year or whatever time that's on 3 years of post-release control, whichever is greater. If that occurs, that must be served consecutively the sentence in the case. You understand all that?
Yes, sir.
I want to go back and clean up the record a little bit. On page 2, I explained to you the minimum and maximum sentences. And the way it's written on the form, it says that each count carries a minimum of 2 years, which is correct. And then at the bottom, it says 8 years total minimum sentence. And that's if I order them to be served consecutively. But if I order them to be served concurrently, then the actual minimum sentence would be 2 years. So I just wanted to make that clear. So the minimum would be 2 years, and if the maximum was imposed of 8 years on all 4 counts plus additional 4 years on count 1, that would be 36 years. And it would be any combination in between there, depending upon what the court does with the sentence. If I order 2 years minimum on each consecutive, then that would be the 8 years, which is example that's listed here on the sheet. Do you have any questions about that? Okay, you understand? Okay. Right now, count 10 alleges that on or about June 9, 2021 in Huntington County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with a fentanyl-related compound, the amount equal to or exceeding, I'm sorry, I'm reading count 9. Let me start over. Count 10. On or about June 9, 2021 in Huntington County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, amount equal to or exceeding 5 times bulk amount, but less than 50 times bulk amount, in violation of Section 2925.03A1. So that's the charge of aggravated trafficking of methamphetamine. Second-degree felony with the penalties I described, between 2 and 8 years minimum of the additional 50% of the term imposed by the judge as a maximum. Count 17 alleges, on or about May 24, 2021 in Huntington County, Ohio, you and Devin Sparks did knowingly sell or offer to sell methamphetamine, Schedule II controlled substance amount equal to or exceeding bulk amount, less than 5 times bulk amount specific to school zone, violation of Section 2925.03A1. So that's also a charge of aggravated trafficking of methamphetamine in the vicinity of the school zone, and that's a second-degree felony, the same penalties as possible in count 1, or count 10. Count 19 alleges the same offense as count 17, except it alleges it occurred on June 24th, 2021, but otherwise it's the same offense, the same penalty. Count 21 alleges the same offense, the same language on about June 28, 2021, with Brian Compton. And actually, I'll go back to count 19 is the offense was committed with Kathy Sparks instead of Devin Sparks. So count 17 was allegedly committed with Devin Sparks, count 19 with Kathy Sparks, count 21 with Brian Conley, also in the city school zone. So all those are the same, all 4 of those are the same section number, same degree. Count 1 is aggravated trafficking of methamphetamine alone, and then the other 3 are aggravated trafficking of methamphetamine in the vicinity of school zone. And then count 33 alleges that on the period of July 9, 2021 to July 12, 2021 in this county, you had in possession a yellow 2007 Dodge Caliber, $218 U.S. currency, and 5 cell phones subject to forfeiture due to their instrumentality, information, or facilitation of offense under 2941.14.17. And the penalty for that is the loss of that property with no jail time or fine. All right, now Ms. Eisen, do you understand what it is you were charged with in each of those cases? Counts what the state said you did, when, where, and how they alleged that you did it.
Yes, sir.
Have you had an opportunity to discuss the nature of those charges, the evidence in the case, the possible legal issues in the case, possible defenses you could try to raise in trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs? Has anyone threatened you to get your plea guilty here today?
Yes, sir.
All right, now on page 2, there's 6.5 lines of printed in bold and underlined, and it's been changed a little bit because there was a discrepancy as to the total restitution and the breakdown. And so that was what was being discussed when he came in the room. I'll go over that with you now. First of all, I'll read those sentences to you. It says, defendant shall enter plea guilty to counts 10, 17, 19, 21, and 23. State will dismiss remaining counts.
It should say 33, Your Honor, not 23.
Oh, no, that's true. Your boss needs a higher proofreader. Yeah, I'm telling her that. 33. I'll change that. The state will dismiss remaining counts. State and defense jointly recommend 2 years on each count, consecutive to each other for a total of 8 years of mandatory prison. Defendant shall pay restitution in the amount of $3,815, and actually, when we were talking before, I had changed the amount, but then Mr. King was able to figure it out and explain it. And so the restitution of $3,815 is broken down to $2,975 that you would owe alone, $240 would be owed jointly and severally with Devin Sparks, $120 jointly and severally with Kathy Sparks, $240 jointly and severally with Roger Gruber, and $240 jointly and severally with Ryan Conley, which is what I added onto the agreement during the discussion before you came in the room, and I made my initials, written my initials and the date there. And then it goes on to say, defendant agrees to forfeiture as outlined in count 33 of the indictment. Defendant will cooperate fully with the task force, including testimony as needed. Now, is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
Yes, sir.
Again, you understand that any sentence imposed by the court is a mandatory sentence that must be imposed. The only thing that would be discretionary would be the additional 50% of whatever sentence the judge ordered that could be imposed by DRC if they decided they should keep you on. You understand that?
Yes, sir.
Under the law, this I said the matter of sentences of the judge, not the parties. So even though there's a recommendation for what the sentence ought to be, the court is not obligated to follow that. So if you plead guilty to these charges, and once I've heard all the information submitted to me, I decide that that's not the correct sentence, then the court could sentence you to any amount up to 32 years as mandatory minimum, and an additional 4 years if possible on count one of the regular code law. You understand that?
Yes, sir.
And Mr. Wagner, there's no disagreement. They're stipulated to the amount of restitution with that addition that we talked about before we went on the record.
Again, you understand that we could arguably contest that amount, or you say, I agree with that. I guess some of those amounts are 27, but you agree with those amounts, Jim?
Is it what you call?
Yeah.
Yes.
All right. Now, Ms. Eisen, do you hold any kind of a license or certificate from any state commission or governmental agency that regulates any occupation or profession?
Yes, sir.
Okay. You have certain constitutional rights, you must understand, before I can accept your plea. First of all, you do have a right to have counsel, and Mr. Wagner was appointed to represent you, not for the purpose of working the case out, but to provide any defense could be available to you under the law that you wish him to provide. So, if you decide that you do not want to plead guilty, that you would rather defend against the charge, he will continue to represent you, including defending you in a trial, if that's what you want. You understand that?
Yes.
The Constitution, Ms. Eisen, you have the right to have a jury trial in this matter, in which a jury of 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty under trial date. Now, after 12 jurors were selected, the evidence would be presented, they'd be instructed on the law, then that jury would have to decide by unanimous verdict, all 12 have to agree, to whether or not to state truth or guilt on any of these 5 charges, including the forfeiture. Now, if you decided you didn't want to have a jury trial, but you don't want to plead guilty, you could waive in writing, which means to give up the right to have a jury trial, and in that case, you have what's called a court or bench trial, meaning that instead of a jury heard the evidence, the judge would be the one who heard the evidence, apply the law, decide whether or not to state truth or guilt. You understand that? Right now, in the Constitution, you have the right to confront witnesses against you to cross-examine them for your attorney. What that means is that the witnesses against you would have to come into court and testify in front of you, and your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney will ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. You understand that? Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court and testify for you, just like the state. So if you have witnesses here on a certain point to come in voluntarily, if you request the court issues a subpoena, which is a portal that forces those witnesses to come to court, be available to testify on your behalf, though they want to be here, which is the same way that the state witnesses are forced to come into court and testify against you. You understand that? Right, under the Constitution, you have a privilege against self-incrimination. It means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's your decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And in fact, no one's even allowed to talk about it except in one situation, and that is, there's a jury trial and you don't testify. The judge instructs the jury that because that is the right, they cannot consider that for any purpose. You understand that?
Yes.
Now, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio and every essential element of these offenses. What that means is that you're not required to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence of your own trial in your defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state. Prove your guilt on every essential element of each offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Right now, under the Constitution, when you entered your plea of not guilty, you denied the allegations in the indictment, denied you committed any crime, and exercised all those rights that I just described. Now, if you change your plea from not guilty to guilty, that's the opposite of not guilty. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed a crime. And that plea waives up all of the rights that I've just described for you, except the right to have an attorney, which you always have no matter what your plea is. That exception.
Can I talk to you for just a second?
Sure. I'm going to create a breakout room. There will be a button there that says join the breakout room. Let me. All right, we're back on record. Okay, so ready to go forward then?
Yes, thank you.
Yeah, she was just confused. You were going through a right. She thought you were going to bring a jury in. I said, no, that's just what she's waiving.
Yeah, okay, gotcha. All right. So, yeah, you're pleading guilty with way to give up that right to have a jury trial on these charges. It would way to give up the right to confront witnesses and cross-examine through your attorney at the trial. It would way to give up the right to require witnesses to come into court to testify for you at trial, just like the state. It would way to give up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. And it would way to give up the right to require the state to prove your guilt on each of these 5 charges, because if you plead guilty, then they don't have to prove your guilt. The subjection being sentenced immediately by the court, which is what's going to happen here since it's a mandatory sentence. It also gives up a right to file an appeal, which you think you may have had up to this point in the case. Now, if I were to sentence you to the maximum sentence available, or under other certain limited circumstances, you can file an appeal. Any appeal will have to be filed within 30 days of your sentence and entry being filed. Do you understand all of that? I'm sorry?
Yes.
Okay, you froze up there. Okay, I lost you for a second there. Did you understand all the things I just said?
Yes.
Okay, and including, what the right of appeal would be or would not be? Okay. Now, you have any other questions you'd like to discuss with your attorney before we go any further?
No.
You have any questions at all, before we continue? All right.
No.
Then is it your decision, Ms. Eisen, to withdraw your not guilty plea, plead guilty to the, 5 counts of the indictment that we've just discussed in this written plea agreement?
Yes, sir.
All right, then as to count 10, that alleges that on or about June 9, 2021, Highland County, Ohio, that you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk, amount less than 50 times bulk, amount in violation of Section 2925.03A1 of the Ohio Revised Code, the charge of aggravated trafficking methamphetamine, a second-degree felony, carrying a sentence of between 2 and 8 years set by the judge, which is mandatory, with a possible extension of up to 1/2 of that sentence added on by the Department of Rehabilitation Corrections, a fine of $10,000 and a mandatory fine of, actually there's a fine available of $15,000 and a mandatory fine of $7,500 and a possible license suspension for 6 months, 5 years, how do you plead?
Guilty.
As to count 17, that alleges that on or about May 24, 2021, Highland County, Ohio, that you and Devin Sparks did knowingly sell or offer to sell methamphetamine, Schedule II controlled substance, an amount equal to or exceeding bulk amount of less than 5 times bulk amount in the vicinity of a school zone in violation of Section 2925.03A1. Also the charge of aggravated trafficking methamphetamine in the vicinity of a school zone in violation of Section 2925.03A1. Also a second degree felony with the same possible sentence. It's count 1. How do you plead?
Guilty.
Count 19, which alleges that the same offense that you just admitted to in count 17 occurred on or about June 24, 21 in this county with Kathy Sparks rather than Devin Sparks. Otherwise, the same offense, the same elements, same statute, same penalty. How do you plead?
Guilty.
Then count 21, which alleges that on or about June 28, 2021 in this county, you and Brian D. Conley committed the same offense as set forth in count 17. No, I'm sorry, Roger Gruber, not Brian Conley, Roger Gruber. It was on July 9, 2021. I was looking at the wrong count. So, as to count 21, which alleges that on or about, I got it right the first time. I'll tell you, my bifocals are messing me up here. So let me start over. Count 21, it alleges on or about June 28, 2021, Highland County, Ohio, that you and Brian D. Conley did knowingly sell or offer to sell methamphetamine, Schedule II controlled substance, amount equal to or exceeding bulk amount less than 5 times bulk in the vicinity of school zone. Same section number, same offenses, count 17, same penalties. How do you plead?
Guilty.
Right. Then as to count 33, which alleges that on or about the period of July 9, 2021 through July 12, 2021 in Highland County, Ohio, you had in possession a yellow 2007 Dodge Caliber with the VIN number in the indictment, $218 in U.S. currency and 5 cell phones, subject to forfeiture due to assist with town commission facilitation of the offense. Defined in Section 2941.14.17 of the Ohio Revised Code. A forfeiture specification that would carry the loss of that property to the state. How do you plead?
Guilty.
All right. The court finds that on this day of the court, the defendant was advised of all constitutional rights, made a knowing, intelligent, voluntary waiver of the same, pursuant to Criminal Rule 11. Plea is accepted and ordered by. The defendant is found guilty. Count 10, 17, 19, 21, all the same, all aggravated trafficking methamphetamine with as count 10, and then the other 3 aggravated trafficking methamphetamine in the vicinity of the school zone, all second-degree felonies, is charged therein, and then count 23 or 33 of the forfeiture. The remaining counts against the defendant are dismissed. and the court will not order a pre-sentence investigation, but will proceed forthwith with sentencing. All right, anything from the state regarding sentencing?
Thank you, Your Honor. The state would ask that the court follow the plea agreement. As far as the forfeitures, there's the $218 in U.S. currency. I've broken down in the entry how that is to be distributed to the various agencies. The cell phones are to be forfeited to the Greenfield Police Department. And finally, the vehicle, the 2007 Dodge Caliber, the title for that vehicle needs to be issued to the Village of Greenfield. And finally, the restitution amounts are outlined in the agreement. So that's everything, Your Honor. Thank you.
Mr. White, anything you'd like to say?
We would ask the court to give, I guess, heavyweight, obviously, the speed in which Jen resolved this case. Obviously, the court's going to have great concern and look at the accounting indictments, the degree of the indictment, or the charges within the indictment. But for getting this discovery, I'm looking at it now with a mobile file to a Brown accordion file, various videos that do a criminal 16. Jen didn't have the privy of watching, but I had to basically explain them to her and what they are. Again, we reached out and communicated with each other, probably had half a dozen visits out to jail, going through everything. Jen never once screamed, take a trial, make them waste their time, I don't care. She had fessed up from day one, Your Honor. And with each count, the indictment, obviously, we should. But again, we would just ask the court to follow the recommendation, Your Honor. Jen's never been difficult. I hate to say it, I'm quit talking. I actually got to like Jen. She just picked a back business to get involved in. That's it, Your Honor.
All right. Ms. Hyson, anything you would like to say?
No, that's it.
All right, well, I noticed that you don't really, you have very, one 4-3 misdemeanors all you have in your criminal record. Here's discovery. But unfortunately, as the attorney said, you picked a really bad business to get into because these were really serious offenses. But you have, and so I'm taking that into consideration, the fact that you don't have any prior record other than a 4-3 misdemeanor, and that you have cooperated, and in this case, it moved along pretty quickly. And so, based upon that, the court will follow the recommendation in the plea agreement for sentencing. So, as to counts 10, 17, 19, 21, it is ordered that you be sentenced to a term of 2 years mandatory prison on each of those 4 sentences. And that those sentences be served consecutively to each other for a total of 8 years. Now, the court finds that the sentence that these offenses were committed as a series of ongoing conduct, and that they're separate transactions, and that no one single sentence would adequately reflect the seriousness of the crime, and the sentence imposed not disproportionate to the harm caused, being limited sentence on it as to each. Now, as to count 1, the Department of Rehabilitation and Corrections could require you to serve an additional 50% of this sentence, which would be another 1 year. So potentially you will have to serve 8 years, it's required. You could serve 9 years if they decide you should stay home. Now, upon completion of the prison term, you will be placed in post-release control supervision by the adult authority under the terms they set for a period of at least 18 months up to a maximum of 3 years. If during that period of time you commit any violations of the conditions that they have established, they can return you to prison and make you serve an additional period of up to 9 months for any one violation, up to half of the prison term for all violations. But if you commit a new felony law in post-release control supervision, then in addition to whatever sentence the judge in the new case can impose upon you, the judge can also sentence you in this case to an additional period of 1 year Whatever time is left on the period of post-release control, whichever is greater, and if that occurs, that must be served consecutively to the sentence in the case. You're also ordered to pay the court costs, which that is granted an execution order. If you fail to do that, then the clerk could collect that through various means, including levy on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, once you complete your prison term, not while you're in prison, but once you get out, then you could be ordered to community service in this county. You give credit for each hour you work in an hour set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, it's also ordered to make restitution to the Highland County Task Force. In the amount of $3,815 as set forth in the plea agreement, jointly and severally, $29.75 loan, $240 joint and several with Devin Sparks, $120 joint and several with Kathy Sparks, $240 jointly and severally with Roger Gruber, and $240 jointly and severally with Brian Conley. Those amounts will be paid through the victim witness office, and you'll pay any fees associated with that. Now, assuming that you haven't had any change in financial circumstances since you were appointed counsel in this case.
I'm sorry for that.
You haven't won the lottery over in jail or anything like that, or you heard any money. All right. Well, the court will then find that you don't have the ability to pay a mandatory fine, or unlikely to have that in the future, and therefore. As far as jail time credit, I don't think I impose that. 22 days, you're arrested on the 7th of February. Is that correct? Yes. All right. So it'll be 22 days of jail time credit. All right. Anything further, counsel?
No, Your Honor.
All right. So we remain in custody. Thank you. Mr. King, on that last case with Mr. Sowers, I forgot to waive the fee for the fine. Put that in the entry.
Yes, sir.
All right. We have Seth Ider.
Yes, sir, Your Honor. I'm going to spin my computer around. He's in my, waiting room. He'll be in my office with me.
All right.
Shut that door.
All right, that's case number 22 CR 33, State of Ohio versus Seth L. Ider. You are Seth L. Ider, appearing there by Zoom from your attorney's office.
Yes, sir.
All right, Mr. Widener is the defendant's attorney. Also appearing from his office is assistant prosecuting attorney King, representing the state. Now, Mr. Widener, you and your client both agreed to waive his presence in the courtroom and to agree to have his matter conducted remotely by Zoom.
Yes, Your Honor.
And that's all right with you, Mr. Ider?
Yes, sir.
All right, Mr. Ider is charged in a 5-count indictment of trafficking marijuana, 2 counts of aggravated trafficking of methamphetamine in the city of and 2 counts of aggravated possession of methamphetamine. This matter is set for trial on April 14th, and actually set for pre-trial Wednesday, and the first final pre-trial on the 16th. All right, now, Mr. Ider, I've been presented with a plea of guilty form, which indicates that you are going to withdraw your not guilty plea, plead guilty to counts 1 and 2. And I'll hold that up to the camera so that you can see it. And is that your, recognize your name and the form number and the plea?
Yes, sir.
All right. And count, page 3, there are signature lines. And about halfway down, there's a sentence that says, I entered this plea voluntarily, and then immediately below that is on a line by which is marked an X in blue ink, appears to be Seth Ider's signature. I'll hold that up to the camera there next to my finger. Is that your signature there, my index finger?
Yes, Your Honor.
When did you sign this agreement, Mr. Ryder?
Today.
All right, and did you sign that with your attorney present?
Yes.
And did he go over with you before you signed it and explain everything to you and answer all your questions?
Yes, Your Honor.
And did you feel that you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And are you entering into the agreement to plead guilty voluntarily?
Yes, Your Honor.
All right, now the agreement states that you are going to withdraw your not guilty plea and plead guilty to counts 1 and 2 of the indictment. And it says that you understand that count 1 is trafficking in marijuana under 2925.03A1, a fifth-degree felony, and count 2 is aggravated trafficking methamphetamine in the vicinity of juvenile under the same section, a third-degree felony. Now, further states that you understand that the maximum penalty for count 1 would be 12 months imprisonment, and then would be 6 months of the prison term imposed. Could be a fine of up to $2,500, off the license suspension 6 months to 5 years. You understand that?
Yes, Your Honor.
Now, count 2, it states that you understand that the maximum prison term for that can be up to 36 months. The minimum would be 9 months of the prison term imposed. There'd be different increments in between those two ranges. You understand that?
Yes, Your Honor.
That also has a possible fine of up to $10,000, a mandatory fine of $5,000, and a license suspension of 6 months to 5 years. You understand all that?
Yes, Your Honor.
Now, under the law, if you're convicted of both these offenses, Mr. Eigner, the court could order these sentences to be imposed consecutively, meaning you would have to serve one after the other. So if that happened, that means the maximum penalty could be 48 months imprisonment and a fine of $12,500 for the two total of the fines. You understand that?
Yes, sir.
Other than these charges, Mr. Eigner, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for any felony?
I'm on probation here in Allen County.
Just for this charge, I mean, in this
I have
case,
this and I have misdemeanor probation.
okay, so no felonies.
No, sir.
Okay, all right. Now, under the law, if you are sentenced to prison for these offenses and serve a prison term, once you complete that, it's possible the adult parole authority could exercise the option to place you under post-release control for a period of up to 2 years. They don't have to, but they can. But if they do, then you'd be supervised by a parole officer on the terms and conditions they set. And if during that period of time they determine that you have failed to comply, then they can return you to prison even though you served the entire term reported by the court for an additional period of up to 9 months for one violation. But there is a cap or limit of half of whatever prison term is imposed for all violations. But if you commit a new felony, while you're under post-release control supervision in this case, then in addition, whatever sentence could be imposed for the felony in the new case, that judge would also sentence you for committing that offense while under post-release control supervision in this case to an additional period of 1 year, whatever time is left on the post-release control term, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. You understand that?
Yes, Your Honor.
Right, under the law, I'm not required to sentence you to prison for these offenses and can impose what's called community control, which means that instead of going to prison, you can put under the supervision of a probation officer for a period of up to 5 years under the term set by the court. And if during that period of time, the probation department felt that you were not complying, then they could return you to prison even though you served the entire, they would file a written notice at the court. And then you would be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing was that you had failed to comply, then at that time the court could sentence you to prison for the 48 months and fine you $12,500. You understand that?
Yes, Your Honor.
All right, now count 1 alleges that on or about October 22, 2020 in this county, you did knowingly sell or offer to sell marijuana, a Schedule 1 controlled substance in violation of Section 2925.03A1. And that's a felony of the 5th degree, with the penalties we just described. Count 2 alleges that on or about October 28, 2020 in this county, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance in the vicinity of a juvenile in violation of Section 2925.03A1. That's a charge of aggravated trafficking methamphetamine in the vicinity of a juvenile third-degree felony with the same penalties we just discussed. Now, Mr. Iger, do you understand what it is you've been charged with in those two counts, what the state said you did, when, where, how they alleged that you did it?
Yes, Your Honor.
Have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible defenses you try to raise in trial, possible outcomes of the trial with your attorney?
Yes, Your Honor.
And are you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made against you to plead guilty here today?
No.
Excuse me. Or Mr. Flushing. Even he knows his plan. It's good to be ahead of. Now, on page 2, there are 3+ lines that are printed in bold and underlined, so I'll read those now. Defendant shall not plead guilty to counts 1 and 2. State will dismiss remaining counts. State will not oppose immediate control and substance abuse treatment. Defendant will pay restitution amount of $320 in consideration of plea offer. Defendant shall meet with investigators. That's your understanding of the agreement?
Yes.
Does anyone promise you anything other than application to plead guilty here today?
No, Your Honor.
Under the law, Mr. Ryder, the matter of sentence is up to the judge, not to the parties. And so, even though the state is recommending community control as will you, I'm not required to follow that when it comes time to sentencing. Once I've heard all the information presented, if I decide that's not the correct sentence, I could choose to send you to prison for between 6 months as a minimum for one charge, 9 on the other, up to a maximum of 48 months total. And I could also fine you $12,500. You understand that?
Yes, Your Honor.
Now, do you hold any certificate or license from any state governing body that regulates any trade or occupation profession? State agency, not a trade organization.
Do you have any certificate from the state of Ohio that licenses you, like an attorney's license or? No, sir.
Okay.
Sorry about that.
No, that's a problem. That's a confusing question to many people. All right, now, you have constitutional rights to understand before I can accept your plea. You have a right to have counsel, and I appointed Mr. Wagner to represent you. Now, I didn't appoint him simply to work the case out, but provide any defense that could be available to you under the law that you would like me to provide. So if you decide that you don't want to enter this plea, that you want to contest the charges, that he'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, Mr. Iger, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, they'd be instructed on the law. And then that jury would have to decide by a unanimous verdict, meaning all 12 would have to agree on each count as to whether or not the state proved your guilt on either or both charges. Now, if you did not want to have a jury trial, oh, okay. I thought they was coming in at the same meeting.
Yeah.
Oh, okay, I'm sorry, tell them I apologize. All right, I thought that we had all these hearings on one meeting, we got a different meeting this afternoon. All right, if you decided that you didn't want to have a jury trial, you could waive and give up your right to have a jury trial, in which the jury would have to agree unanimously on each count, and instead have a court trial, in which the judge would be the one to hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether or not state proved your guilt or proved beyond reasonable doubt. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to use the power. You have a right to front the witness against you and cross-examine them for your turn in open court. So what that means is the witness has to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, Your Honor.
And under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify on your behalf the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, the court issues a court order called a subpoena, and that would force that witnesses in that court order or subpoena to come to court and testify on your behalf, even though they didn't want to be here, which is the same way the state's witnesses are forced to come in and court and testify against you. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have the privilege of self-determination, which means you can under force give evidence in this matter at any time, including trial. No one can ever be to testify. The prosecutor can't, the judge can't, it's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to talk about it except in one situation, that is, if there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of each of these charges by proof beyond reasonable doubt. What that means is that the burden of proof is on you to try to show you're not guilty simply because you're accused. In fact, under the law, you're not required to present any evidence in your own defense at all. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of each of these offenses by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
Right now, originally, Mr. Ivory entered a plea of not guilty to this charge. The charges, that plea denied the allegation in the indictment, denied he committed any crime, and exercised or invoked all the rights that I just described. Now, if you change your plea from not guilty to guilty, that's the opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime, and that plea waives, gives up all the rights that I've just described for you today, except the right to have counsel, which you always have no matter what you plead. Without exception, your plea of guilty waives, gives up the right to have a jury court trial, waives, gives up the right to confront the witness against you, to cross-examine in open court, it waives, gives up your right to use the power of the court to require witnesses to come to court to testify on your behalf of the state. Waives, gives up your privilege against self-incrimination because you're the one saying you're guilty, and that's what you find guilty. It waives, gives up your presumption of innocence because if you plead guilty, the state doesn't have to prove you guilty. And waives, gives up your right to file an appeal on any alleged violations of your rights you could occur up until today. Now, if you are sentenced to the maximum sentence or under certain limited circumstances, an appeal can be filed, an act can be filed within 30 days of your sentencing and being filed. You understand all that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
I also should say it would subject you to be sentencing by legally by the court if that's what the court felt should happen, although it's something to do. You understand that?
Judge said he could send you today, but that's not what's going to happen. But he has that right. You understand? Yes, Your Honor.
All right. Now, Mr. Wright, do you have any questions about any of the charges or the two charges or the possible penalties?
No, Your Honor.
Do you understand them?
Yes, sir.
Any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, sir.
You have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
Yes, I do.
You have any questions about the plea of guilty, what it means, what the consequences of that will be if you enter here today?
Yes, Your Honor, I understand.
Okay. Is there anything else tonight you'd like to speak to Mr. Wagner about before we're going further?
Nope.
You have any questions about anything I've explained today?
No, sir.
All right, then as to the charge of count one, which alleges on or about October 22, 2020, Huntington County, Ohio, you did knowingly sell or offer sell marijuana, Schedule 1 controlled substance violation, Section 2925.03A1, Ohio Revised Code, a charge of trafficking marijuana, 53 felony, carrying possible prison term between 6 and 12 months, fined up to $2,500, and possible license suspension 6 months to 5 years. How do you plead?
Guilty.
As to count two, which alleges on or about October 28, 2020, Huntington County, Ohio, you normally sell or offer sell methamphetamine, Schedule 2 controlled substance, vicinity of juvenile violation, Section 2925.03A1, charge of aggravated trafficking methamphetamine, vicinity of juvenile, a third-degree felony, carrying possible prison term between 9 and 36 months. In increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. you. The court finds that on this date of the court, the defendants advised all his constitutional rights made no excuse of voluntary waiver, sentence under Article 11, pleas and second order filed. Defendants found guilty of counts 1 and 2 is charged therein, counts 3 to 5 are dismissed. Court will order a pre-sentence investigation of the same bond. Sentencing will be set for April 13th at 9 a.m. Bond is continued. So you need to contact the probation department as soon as we get down here. Either walk down there and call from Mr. Weiner's office, set up an appointment to meet with the pre-sentence investigative officer, Mr. Plea.
Yes, sir. Yes, Your Honor.
Anything further, counsel?
No, Your Honor.
All right, Mr. King, are you handling the Erskine case or this policy? I've got to sign off.
I'm not sure, Your Honor, one of us will log
Okay.
in then.
All right, I'll have to sign off for this one and then open that one. Okay.
Yes, sir.
Yes, sir. Okay, I recognize that wall. Okay. Now, the prosecutor's got to sign back in, so we're waiting on them. Oh. Ms. Gilmer, okay.
Recording in progress.
All right, we have 2 cases before the court involving the same defendant. Dave Weiner's a tie, Timothy Erskine, and this hearing is being conducted by Zoom, and you are Ty Timothy Erskine, appearing there from the probation department. Okay. Mr. Erskine's attorney is David Washington. He's appearing from his office by Zoom, and then prosecuting attorney Collins is representing the state. The matter before the court is a request for a continuance in 2 cases that we have. One on CR 141 and 142. 141 involves 3 drug offenses and a forfeiture specification, and 142 involves a failure to comply. And I know in the last pre-trial we had talked about going ahead and trying a failure to comply on the 7th, and then continuing the other one, but I don't think that I ever actually did anything. And then after that hearing, Mr. Washington filed a motion to continue on the basis that there is a conflict. And what we're having trouble understanding, Mr. Washington, is the rule of superintendents requires that if a case was scheduled previously, that there be a copy of the assignment of showing that. That wasn't initially included, and your assistant did send something up, but it's a little confusing, so perhaps you could educate me on it. On the it's Eugene Chambers, Judge Shanahan, and it's it's a bench note type entry, and it has a file stamp November 30, 2021, in which there was a waiver of time and a continuance to the 14th of February at 9 a.m. And then below that it says jury trial 3/7/22 at 10 a.m. So my question was, when was this set?
That was filed on November 30th. There should be a timestamp at the top corner.
Okay, so this was all, so that's, so in other words, that was all done at the hearing on November 30th, even though originally it had a February 14th trial date?
No, the February 14th I thought was our pre-trial. And then,
well, it doesn't really say, okay, I'm sorry, yeah, it doesn't really say, right? Okay, well, what it does, it says plea or trial setting, okay.
It was February 16th.
no.
Now, that's 14 what I'm looking at, yeah.
Oh, sorry.
Yeah, it's all right,
I'll go on something different. This
okay,
is a case I have in Hamilton County.
okay,
Oh,
all right. Well, all right, so based on that, and since your client is on bond, there's not a speedy trial time, and we do have another case set on the time stands when to go, Ms. Collins, the Engel case.
Your Honor, I can't get a hold of the defense attorney. I've sent emails.
Well, we haven't heard anything either, so it's gonna be more, so,
I sent her a plea rejection form. I left a message. I sent an email.
okay,
I don't know what she's doing.
all right, well, and that defendant's not in custody either, is he?
No, he's not.
Okay, I don't even know, what is the charge in that case?
Kidnapping, or robbery, and
Okay,
kidnapping.
all right, well, that's the case, we'll try that, so I will go ahead and continue this. Now, you have your calendar there, Mr. Washington?
I do.
All right, let me see what we can do here. So, what I think I'm going to do is we'll set the failure to comply for a separate trial from the drug case. And I'll just go ahead and, I think I've got a hearing date or a trial date on the other drug cases, so we'll go ahead and use that one for the time being. And then if there's any issue about whether or not those can be tried together, then that motion can be raised.
So is that the April 28th date you're referring to?
Is that the date? I'll remember, okay? Yeah.
Okay.
All right, here, Ben?
Yes.
I need some more of these. We only have 2 left.
Okay.
Yeah, I'm going to do that when you get a chance to finish the supply.
Right.
All right, so, for 21, if you go ahead and do that one, wait, let me scroll down here. 21 CR 142, failure to comply. We have one set on the 24th of March, Ms. Collins and Christopher Owens. Is that one that's likely to go?
I'm not sure. That's Miss Barger's case. And,
Is he in custody?
no, he's out.
All right, he's a fairly new one. That's a 22 case. Are you available that day, Mr. Washington?
I missed what you said, Judge.
March 24th.
I'm in an aggravated vehicular homicide trial in Cincinnati.
Okay. How about August 31st?
August?
I'm sorry, March 31st. March 31st.
Okay.
Judge, Sexton. I've got a domestic violence trial.
On April the 4th.
I have a rape trial with life details on it. That's big.
This is marked out, I think, because that's not supposed to go on vacation. Did I cancel?
Yeah.
Okay, yeah, that was it. Cruise ahead, I can't get it, right?
Just, I think that we sent in time waivers as well.
Pardon me?
I thought that we sent in an executed time waiver.
Well, that's not the problem, I gotta get this case done within 6 months.
Okay.
And, they're actually putting me outside of that, so it's not gonna be, it's not gonna work. Now, let's see, when do we have it rain? It was rain in January, okay, we're still okay then, alright. Pardon me?
The ring.
It was rain in January.
I thought one of these cases had been pending.
They were, died on September 14th, but, rain was on January 4th. April 18th.
I'm leaving town on the 19th.
Pardon me?
I'm going to Cabo on the 19th.
Going where? Cabo?
Yeah.
Okay, well, we'll be done on one day. I mean, these kind of cases shouldn't take more than a couple hours, as far as evidence is concerned, I would think. So, we start at 8:15, should have a jury by 10. So what time, is your flight out on Cabo?
That's my girlfriend, but if we can do it in one day, at 18th, I'll be there.
All right, we'll do it. That's great motivation. All right, for everybody.
Do you hear this?
Yes, sir.
Okay, and you're gonna have to come in. I got a thumb drive in the mail from the prosecutor today.
All right, April 18th, right?
Yeah, but okay, yes.
He wants you to come in before that, Mr. So you can get in touch with him.
Yes, I just wanted to make sure I had the right date.
And we also have we have another phone conference on the other case time too. Sometime.
Yeah, I don't know, does anybody know this off the top of your head?
Yes.
I know the trial date on the other one's the 28th.
Right, and I've got a telephone pre-trial with March 17th at 2:30.
All right, let's just set this one in too, that'd be by Zoom. All right, it's the 17th at 2:30,
Yes.
all right? So that'll be the order in, this case, and then, the trial date, and, the pre-trial in the other case will be the 17th, and the trial date will be set for the time being for the 28th of April on the 141 case. All right, anything else then we need to discuss at this time?
Only that, I forwarded, plea rejection forms to the defense, so we just need a copy of it, or we just need those back when they're signed.
Again, time I'm going to meet very soon, and I'll get those back.
All right, anything else?
Thank you.
All right, thank you.